The other thing I want to talk about real quick is earnest money. A lot of confusion about whether earnest money, the acceptance or receipt of earnest money means there's a contract. The contracts do not require earnest money. Contracts don't require deposits. Contracts are simply agreements between the parties. So if you don't have the earnest money, it doesn't mean that you don't have a contract, unless the contract says otherwise. Our contract doesn't address the earnest money in that fashion. The old contract didn't either. The old contract was actually kind of confusing because it said that if your check bounced, then the contract would be canceled. And I never understood that. I thought that you had a contract already. It had nothing to do with earnest money. What this one does is if you don't get the earnest money in 3 days, the seller can void the contract. It says that within the earnest money provision. So the seller can void it if you don't have the earnest money in 3 days. At least that gives a time period. Here's why we had problems with the earnest money. Now we're going to electronic signature. It used to be that somebody came in your office and signed an initial and gave you a check. Now they're doing it online and you may not see them. And the old contract will be, I know a contract in Tuscaloosa, I just got through with one, that says, earnest money is hereby acknowledged as received. Well, it wasn't. It's all done electronically. Okay, it's not received. Nobody has it yet. And nobody got it. And that was the whole problem of the lawsuit. Because the contract acknowledged receipt, but it didn't say by who. And there was no way you could even think it was received because it's all electronic initials and signatures. So this way you can still do the electronic side of it and say, you got 3 days to get in my office and give me a check or mail it to me, overnight to me, whatever you want to do, or they can void the contract. So
The
seller.
What if the buyer decides that they want to void the contract after 3 days?
They can't.
Okay.
They're obligated
Because
to the
of
contract.
the paperwork. Okay.
So at least, they're obligated, so the contract, if that was the case, the buyer could string you out and say, yeah, I'll get you earnest money, I'll get you that sort of thing. This way, the seller can say, you're out of here, it's a done deal, we're over with, or, no, I'm going to enforce the contract against you, I need your earnest money, and I got a closing date, or you got inspection periods, or whatever you want to do. No, let's talk about it. We changed the earnest money provision of the contract, too. And Tommy, you may want to look at that and compare it with the old one. Because the old one said something that was real interesting. The old one said if there's dispute about earnest money, then the agent could interplead into court. And I'll talk about interplead in just a second. If it said if there's a dispute about earnest money, the agent could go to the court and interplead it. But then we had that mandatory mediation arbitration provision that said this arbitration provision applies to paragraph whatever the earnest money provision was. So it was ambiguous, it was confusing. Do you interplead it? You've already said you got to arbitrate it. So it was contradictory. It didn't make sense. What we've done here, we've added that paragraph 3 in the middle, that's section 3, it's on page 3 of the contract, paragraph 5.
Okay.
If you look in the middle of the paragraph, you see the little 3, or disperse the escrowed funds in accordance with the directions of a non-appealable order of a court of competent jurisdiction. Okay, here's the way it used to be played out. Either you held it until they could agree to it and get a mutual release, or you interplay. We've added a third provision which allows this to happen. Let's say that buyer has a legitimate reason to back out of the contract, and financing, couldn't get financing, it's contingent upon financing. They want their earnest money back. Seller says, no way, I'm not giving back the earnest money. The buyer can file suit in small claims court for the earnest money and just sue the seller. Or the seller can sue the buyer. Well, either way, not bring us into it. Whatever the court decides, we will do. In our old contract, we didn't have that provision. We had to say we need to interplead it. This way, we don't have to get involved in it. We can say, look, if you want it, go sue. If we have to interplead it, we're coming back against you for the attorney's fees. And that was always, I didn't like that. I didn't like the fact that the person who's entitled to the earnest money had to pay for the company's attorney's fees to interplead the money. I didn't think that was fair. If they're entitled to the money, they're entitled to all the money. So it's a way to encourage your buyer. The broker should sit down with the buyer and say, look, if you think you're entitled to the earnest money, go to the small claims court, fill out the form, you'll get to court within 30 days, and we'll do whatever the court says. As simple as that. Yes, ma'am.
In that case, if the buyer goes and does that, the cost for filing that Does it come out of the earnest money? Is it their cost, or they get it back from the
Typically, the
prevailing
judge
party?
will award it to the prevailing party, typically. And that was so that's why we would get attorney's fees. If Coldwell Banker said, I've got $5,000 of earnest money, go interplead into court. Coldwell Banker can't file that on itself because it's a corporation. Corporation has to have a lawyer, an LLC has to have a lawyer to represent it. So y'all are stuck. Y'all got to get a lawyer to do this. So I charge, I don't know, $500. And I'm going to just interplead to court. I say to the judge, Judge, this is not my money. You decide whose it is. That's all interpleader is.
Right.
We just take the funds, say, here you go, clerk of the court. You decide whose it is, we're backing up. Well, that costs money for us to do it because we've got to file a pleading, got to go to court, all that sort of stuff. The judge will then say, I'm going to award the $5,000 to the buyer, and I'm going to award Mr. May $500 of attorney's fees out of the $500, which I never thought was right. But that, so I'm trying to figure out a way to protect the person who's entitled to all the money, and the way to do it is let them go down to small claims court, file, $160 filing fee, or whatever it is, and say to the judge, Judge, it's my money, and this is the reason why. And the judge says, okay, it is your money. You get your $5,000 plus $160 of filing fee. That, and all we do is we just say, y'all let us know when you get it solved.